Brian, I can't see very well. Is it just Commissioner Mitchell online? Okay. Do you know if we were expecting any other commissioners? I don't. Are you ready, Bev? Okay, let's go ahead then, and it's 10 o'clock, so let's go ahead and go on the record. Good morning. We are in room 139 of the James C. Kirkpatrick Building. This is a rulemaking hearing for the Public Service Commission. My name is Nancy DePel, and I'm the regulatory law judge presiding over these hearings today. We're here in 3 commission cases, which are OX-25-0104, 0105, and 0106. And those cases involve a number of rules and proposed rescissions. And I'm not going to read through all of the case captions because we're on a bit of a time crunch today. We have a local public hearing and another case going on today, and we want those who want to participate in that and the commissioners to be able to participate in that. So we will, at some point, if this hearing goes to 12 or later, we will need to take a lunch break and return after a while to finish the comments. But basically today we're going to start with the first case and take comments on those proposed rules and rescissions, and then we'll go to the next case and take comments on that, and then finally the third case, and that way we can try to keep all your comments straight. I appreciate those of you that filed written comments, and also we're here on Friday, December 6th. We had the first of these hearings because of a bit of a scheduling error in the publication. We kept the record open from Friday to receive comments on those rules also today so that everyone's comments would be considered and we could have it all in one place for the most part. We did receive some comments on Friday, and of course those will be considered, as will all of the written comments. I have Chair Hahn with me today and some of the commissioners online. I know Commissioner Mitchell was online. There may be other commissioners as we go. And I'm going to dispense with, there's no need to take entries of appearance since this is a rule comment hearing. It's not a contested case. There's no witnesses. I won't swear you in. Anyone can give comments. You don't need to be represented by an attorney. The attorneys are welcome to give comments. And we have a lot of different parties in the audience today. I know a lot of you want to make comments. And so I will not belabor that. I think that's about it. Commissioner Hahn, Chair Hahn, did you have anything before we begin?
Good morning, everyone. Thank you all for attending this rulemaking hearing. I am thankful for your comments, though they are quite extensive. And I want to especially say thanks to our staff for bringing this rule out of a 2018 workshop to bring it to completion. So thank you so much, and thank you for the comments. Look forward to hearing from you today.
And I will mention, when you give comments, I would like you to state your name and if you represent someone, who you represent. But to mainly, if you're not seated near a microphone, if you could come down to the podium, please, so that everyone online can hear, the court reporter can hear, and we can get all of the comments taken down. Are there any questions from anyone before we begin? Okay. Well, we will begin with, in the matter of the Commission's proposed Rule 20 CSR 4240-10155 and proposed rescissions of 20.015, 40.015, 40.016, and 80.015. Relating to affiliate transactions for electrical corporations, gas corporations, heating companies, certain water corporations, and certain sewer corporations. I spoke with our staff before we began, and they preferred to go at the end of the comments. I know OPC had some presentations during part of the comments. Did OPC want to lead us off, or? All right.
Yes.
Okay.
Just as a point of, or just as a question, would you prefer us to give our comments from our seat here or to go to the podium?
As long as you speak into the microphone, you may stay at the table, it's fine.
Okay. I think we may do both, if that's okay.
That's fine as well.
All right. Thank you, Judge.
If you could give your name and so forth for the court reporter in the record.
Lindsay Van Gerpen, and I'm an attorney with the Office of the Public Counsel. And I'm joined this morning by John Kleiser, who's also an attorney with the OPC. So good morning, Commissioners, Judge DePel. My name is Lindsay Van Gerpen, and I'm here this morning on behalf of the OPC. The OPC appreciates the opportunity to speak today to give comments on these three very important rules. And you will hear from me at least 3 times this morning, as I will give a short overview of the OPC's positions in each of these cases. You'll also hear from some other members of the OPC as they address more specific issues. So beginning with the affiliate transaction rule, the OPC has submitted its written comments and continues to support most of its suggested modifications to the Commission's proposed rule. Ms. Lena Mantle's memorandum describes the OPC's 20 proposed modifications and the rationale for each of those modifications. She is also here this morning, and I encourage you to ask her any questions that you may have. Ms. Mantle is certainly a wealth of knowledge, and it is no exaggeration to say that she helped write the book on affiliate transactions, as she is one of the authors of the current affiliate transaction rules. She has over 40 years of experience in this field, including 29 years with the Commission's staff. Mr. John Kleiser, as I mentioned, is also one of the attorneys with the OPC, and he will be speaking here in just a moment about the OPC's comments with regard to Section 2F. Mr. Kleiser will explain the OPC has updated its modification of this provision in light of the comments that were made. And as you will see, the OPC, we're not trying to create an unworkable standard, but we're trying to ensure that the Commission has the information necessary to make informed decisions that balance the interests of all involved. So before I turn this over to Mr. Kleiser, is there any questions for me?
Are there any Commissioner questions? And those of you online, just speak up if you have questions. I don't think we do right at the moment.
Thank you.
Good morning. As my compatriot, Ms. Van Gerpen, already indicated, my name is John Kleiser, and I will be speaking specifically with regard to the proposed revisions, Section 2F. So I'm just going to go over a little bit at the beginning of just a brief overview of the affiliate transaction rule, kind of to set the groundwork for why I believe this is important. And to start with, just what is the purpose of the rule? And the purpose of this rule is to prevent a utility from subsidizing its non-regulated operations. That's not me talking, that's the stated purpose from the purpose section. And really the general operation, the core element of that rule is really boiled down to just section 2A, which simply says a covered utility shall not provide a financial advantage to an affiliate. That is the core impetus behind the rule that prevents the subsidization from occurring. So what is a financial advantage? It's a little bit complicated. You'll sometimes hear it referred to as the asymmetric pricing system, but the basic way is when a utility is buying from an affiliate, you have to pay above the lesser fair market price or fully distributed cost, and when you're selling, you have to pay below the greater fair market price or fully distributed cost. Now, I'm just going to talk in terms of selling. It's relatively easy to understand that the inverse occurs when you're buying, but the general gist of the idea is you shouldn't have a utility paying more than it needs to for goods or services, because if they are, they're subsidizing. So let's look at a basic, simple example. We're going to talk about a generic utility called Missouri Utility Company, and it's owned by a parent company. We'll call it American Utility Company. And for the sake of this example, I'm going to say that American Utility Company owns two other subsidiaries, American Support Co. and Iowa Utility Company. Iowa, of course, doing business in Iowa, as you would imagine. Now, under the definition, all four of these are qualified as affiliates. They all belong to the common control of American Utility Company. So this is a very simple affiliate structure that you might expect any number of our utilities to operate under. Let's assume, for the sake of argument, that Missouri Utility Company is going out to try and figure out how to acquire accounting services, for example. So the first thing it would do is it would say, what would it cost us to hire up the number of people we need to do those accounting services ourselves? And let's say that they come to that end and say it's about $1 million. They then turn around and ask their support company, how much would it cost for you to provide the services? And that number is $500,000. Now, that's obviously below what it would cost the utility company to provide itself. That's the fully distributed cost. So that box is checked. But let's say, for example, that in this scenario, the utility was to go to market and it found that there was a generic accounting firm that was able to do it for $400,000. Now, under that scenario, we now have a fair market price for those costs, which is $400,000. And so the utility really isn't supposed to contract with its support company because it costs $100,000 more. That's how the rule currently is supposed to work. So what happens with 2F? Now, the language of 2F, which is it's rather large, effectively says that as long as the utility is buying from its support services company at fully distributed cost, the rule just doesn't apply, or rather, the core element, 2A, just doesn't apply. It also says that if it's buying from another regulated entity at fully distributed cost, again, Section 2A just doesn't apply. So if we return to the example I just gave, under this scenario, the utility would be able to contract with its support company over the alternative and cost customers $100,000 more. That would just be how that would work. And that really kind of underlies the core problem, as the OPC sees, for why this elimination of 2A is a detriment. Now, there is another example I want to kind of run through, and that has to deal with the second half of 2F. So this is the regulated utility dealing with other regulated entities. Let's assume, for example, that Missouri Utility Company enters into an agreement to buy energy from Iowa through a PPA, which is at the cost for Iowa to produce the energy, but above the SPP market price. Again, under the rule as written, they can just do that. They can pay more than the market price for the energy they're buying from Iowa as long as they can show that it's at the cost of whatever it is for Iowa to produce. And that is a direct example of subsidization. I mean, there's just no way around it. And again, that's something that we think shouldn't be something the Commission is promoting. Now, there is a safeguard in place here, and I just want to touch on this very briefly. That safeguard is the language that effectively says that the Commission can, after a hearing, find that whatever is happening is against the purpose and intent of the affiliate transaction rule. Now, I believe that this doesn't work for two reasons. The first is that you're providing a financial advantage is always against the purpose of intent of the affiliate transaction rule. And then much more importantly, because of the changes to the rule's evidentiary standards, you effectively eliminated the ability for the commission, its staff, or any other party to determine what fair market price is under either of these scenarios. The first one is relatively easy to understand. Again, the purpose of the rule is to prevent subsidization. The definition of subsidization is to gift money or other property by way of financial aid. So the second you start providing a financial advantage, you are by definition subsidizing. So again, providing a financial advantage is by definition against the purpose of the rule. The second issue is a little bit more difficult to grasp, relatively, but the short version is that the changes that have been made to the evidentiary standards all include a provision that they don't apply in the event that 2F is applicable, which means that as soon as you have an affiliate buying from its shared services company or another regulated entity, all determination of fair market price just drops out. You have no evidentiary burden to establish what fair market price is whatsoever. And that will effectively mean that it's going to be impossible to establish, or that the utility is in fact costing customers more, because there will be no evidence in the record at all to examine the fair market price. Now, that's kind of where I was intending to end this, but as was stated, Ameren, Missouri sort of filed their comments last night, and despite what seemed to be a little bit unnecessary hostility, when we read the comments, honestly, they did make some good points, and it's worth bringing up those points and kind of discussing them, because as Ms. Van Gerpen said, the OPC isn't interested in making an unworkable rule. We want this to work. In fact, I would say that I want utilities to have support service companies. They do provide a lot of benefit, and they should use them. The purpose of the OPC's comments was never to prevent that, or rather to make it too difficult to work. So at a high level, I want to address the idea, and this is echoed actually in the comments provided by staff. Everybody seems to be operating under the assumption that because a support services company isn't operated for profit, it just automatically doesn't matter. You don't have to worry about it being overcharged. And that's frankly just doesn't make any sense. A support services company could still overcharge even if it's not operating by a profit, simply because its employees are being paid more than the average of what their employees would normally be paid. That is a concern that the commission and its staff and other parties like the OPC would want to investigate. You know, are the costs of the support services company reasonable? But the problem is, because the support services company isn't itself a regulated entity, it's not subject to a prudence review. So the only way you can understand whether or not the costs being charged by the services company are reasonable is to compare them to third-party alternatives. And that's really kind of why the affiliate transaction rule works. Now, another issue that was sort of raised by Ameren was the idea that, you know, if this rule is in place, the company will have to go to market. It will have to get competitive bids for every element of its service company, and that's going to cost a massive amount of time and energy. And if you do get a lowball bid, then suddenly we're stuck with that, and we have to fire all the people in the support service company. I want to make this clear. None of that is the case. It has always been the part of the rule that you don't have to do competitive bids. And the OPC is stressing, we're not asking for competitive bids. I want to especially draw attention to this. The existing rule, section 3A, went too far there, states that when a regulated utility is buying goods and services, it can either use competitive bids or demonstrate why competitive bids are neither necessary nor appropriate. And the OPC was always fine with this language. So if the issue from the companies is they don't want to have to do competitive bidding because it's burdensome, we agree. You shouldn't. You should literally use another method. And in fact, the rule outlines what that other method could well be. Under 3D, it basically says that in order to meet the requirements, you need to follow your CAM. And when you follow your CAM, you can use benchmarking practices to achieve compliance. That is a very simple, straightforward way that you can eliminate a lot of the concern that surrounds this rule. All the support services company ever need to do is establish that what they're charging are relatively consistent with the market standard. And they can do that through benchmarking. Now, I want to draw attention to the proposed language in this rule that has the definition of fair market price, to again point out that the staff is already aware of this because they themselves have said, yes, you can use benchmarking, price inquiries, or other reasonable methods for achieving the standard for fair market price. In fact, the staff definition goes so far as to say if there's no readily available comparative market price, then the FMP is just the fully distributed cost of the providing entity. So again, if you're a support services company or you have a utility that has a support services company and they want to say, we don't think we can go to market for this support company, then you automatically just use the fully distributed cost of the support services company. So having section 2F that just says the rule no longer applies is unnecessary because the rule that you've written already solves the problem by saying, yep, you don't have to go to market, you don't have to go to, all you have to do is prove that these are relatively comparative to market norms. And again, that's really what I want to stress to you. All the OPC is asking, the bare minimum, is that a utility that has a support services company can demonstrate that the costs being charged are within market norms, that customers aren't being overcharged. And the obvious middle ground to do that is to maintain Section 2A and just include the language that staff already has that says, hey, the utility can use benchmarking. And if you can't use benchmarking, if there's literally nothing available, then you can go to the fully distributed cost. It literally accomplishes the exact goal that 2F is attempting to do without needing to use 2F. So, to summarize, with 2F in place, you eliminated all oversight regarding what it costs the utility to provide corporate support services. The evidentiary standards are gone. As soon as that support services company can show that it's not making a profit, no one has to show anything regarding what those costs could be. They might be 2, 3, 5 times the cost. Doesn't matter. Without 2F, you still have to show that the corporate support service costs are being benchmarked against something in the market. What is the evidentiary standards? Again, they don't exist with 2F, but without 2F, you can use benchmarking or other similar standards to meet your goal. And then the third point is, again, just to say, with regard to the second part of 2F, the part that says between regulated entities, with that in place, a regulated entity can subsidize another regulated entity as long as they establish fully distributed cost. Even if they are selling selling below market price or buying above market price, as long as it's fully distributed cost, they can subsidize. That part shouldn't be allowed just flat out. I mean, that is literally just subsidization, and it shouldn't be happening. So in conclusion, I just want to raise this basic question to the Commission. How will you know if shared service company costs are reasonable if there is no prudence evaluation and the affiliate rule doesn't apply to them? The answer is that there is no answer at this point. There's no way to determine whether or not the costs being charged by a shared service company are reasonable because you can't establish what their costs are based off of with a prudence review because you can't review the services company, and there's no affiliate transaction rule. There's no evidentiary requirements, so it's just whatever it's cost, that gets passed on. The OPC believes that these can be solved by removing 2F and allowing for the existing language that effectively says you can use benchmarking, and in the event that you can't, you can use fully distributed cost. That is the simple solution that resolves this problem. That was the conclusion, if I have any questions.
Can we get a copy of your PowerPoint to
Absolutely.
include it in the record?
The one thing I would ask, this is going to be a bit weird, but there's one point where I have this graph 3 or 4 times, and it's just a trick of how the PowerPoint works. I will omit that so it just shows up once. But with that edit, I'll be happy to supply this to you.
Okay, I will mark that just as Exhibit 1 for today's hearing, and we will get that from you. Are there any commissioner questions, Chair Hahn?
Good morning, Mr. Kleiser. How do you respond to Amren's comment that these services are provided at cost to no profit and with no profit to those service companies?
Again, well, first of all, I'm not disagreeing with that, and the OPC has never disagreed with that. The principal problem is that that doesn't resolve the complete issue because there's still the opportunity, or rather the possibility, that support service costs might be overcharged. A basic example of that could be if the support services company is paying more than the average wage for whatever individual they're hiring. Like I used an accountant as an example. Again, that isn't a profit to the company, it's just an increase of costs. And all the OPC is saying is we should be doing something to benchmark that. Like, you should have something to compare that to. But yeah, no, they're not making a profit, and that's fine. That's why we support the service company as a general principle. We just want a standard for them to be applied against to show that the costs being incurred are, in fact, within market norms. I don't feel like that's a terribly high burden.
Thank you, Mr. Kleiser.
Any other commissioner questions?
Sorry.
All right, thank you, Mr. Kleiser. Is that concludes OPC's comments for this part? All right. I didn't do a sign-up sheet or anything like that, so I'll just kind of start with the next table, maybe. Mr. Fisher, did you have any comments you wanted to make?
My client, Evergy, did file some written comments, basically concurring with Ameren's comments, so I think it might be appropriate to have Ameren go next.
All right. Would Ameren like to give comments?
Yes, Judge, thank you. I'm Jim Lowry. I'll be giving brief comments on behalf of Ameren, Missouri this morning, and with me today is Mr. Tom Byrne, who is the former Senior Director of Regulatory Affairs for Ameren, Missouri, who's going to provide most of our comments on this particular topic on the affiliate transaction rules. Our comments today will build on the comments we filed last Friday. We also filed responsive comments that Mr. Kleiser referred to in advance of this hearing, frankly, as a means to reduce hearing time and consuming transcript space so that we didn't have to verbally state all of the things that we put in those responsive comments yesterday. I think the Commission's practice in the past has been to mark such responsive comments as an exhibit and make them part of the hearing record. I have a flash drive for the court reporter that I was going to give to her if it pleases the Commission to do that, and I guess it sounds like we have an Exhibit 1. I might suggest that our two documents, which would be the comments filed yesterday and the exhibits supporting them, could be marked as Exhibits 2 and 3. I was going to suggest maybe AT 2 and 3, but since you're segregating the records, maybe that doesn't matter. But I would ask that those comments be made part of their hearing record that were filed yesterday as Exhibits 2 and 3.
And I will mark those comments as Exhibits 2 and 3, and since those are the same comments that you filed, we won't need the flash drive.
That's
but
fine.
I appreciate it.
As I mentioned, the primary commenter today will be Mr. Byrne, but I did want to touch on just one issue first, and then I'll turn it over to Mr. Byrne to address the rest of the issues. In a nutshell, our December 6 comments, we had suggested an edit to subsection 2F2 that was designed to allow us to share information as part of, quote, day-to-day communications with affiliates for the purpose of improving service, operations, or efficiency. I view these as, the engineers in Ameren, Missouri and Ameren, Illinois sharing best practices and things they've learned. They use a lot of common equipment or just other types of things like that that might literally have been prohibited by the rule because of the provisions relating to provision of information if we didn't have essentially an exception. Staff filed comments today, as a matter of fact, and they agreed with that language, and I think it is important that we recognize that we have benefits from having holding companies with utilities that have common standards and use a lot of the same equipment, and they learn things from each other, and that we don't want to stifle that by technicality in the rule. So we would urge the Commission to adopt that provision. Other than that, the issues about the service company and those kinds of things, I'm going to turn it over to Mr. Byrne and let him address those issues on our behalf this morning, unless somebody has some questions about this information issue that I raised.
Any questions? I don't believe so. Go ahead.
All right. Thank you. I'll turn it over to Mr. Byrne at this time.
Good morning, Commissioners and Judge DePel. As Mr. Lowry said, I'm Tom Byrne, former Senior Director of Regulatory Affairs for Ameren, Missouri. And as Mr. Lowry said, Ameren, Missouri filed 2 sets of written comments, and I won't address all the things in there, but I would like to hit some of the highlights in terms of our response to Mr. Kleiser's comments on Section 2F of the rule. First of all, I think we disagree with several of the points that Mr. Kleiser made. And we also think that if 2F is amended in the way that the Office of Public Counsel suggests, it'll be a significant problem for all the utilities that use a service company, or even I think Evergy doesn't use a service company, but it gets corporate support services from a utility, a sister utility. Some of the things we disagree with in Mr. Kleiser's presentation. First of all, we don't believe there's any financial advantage. And that's the purpose of the rule, is to prevent the utilities from providing a financial advantage to their affiliates at the expense of the customers of the regulated utility. We do not think if a service company provides a corporate support service at cost with no profit, we do not think that constitutes a financial advantage. So the whole premise of the problem he's trying to solve, we believe, does not exist when there's a corporate service company that provides at-cost services. Mr. Kleiser also said that service company transactions would not be subject to review by the Commission, and we disagree with that as well. In our case, for example, in our rate cases, the staff and the other parties and the Commission exhaustively examine transactions with the service company. The information is subject to discovery. There are thousands of data requests that ask questions about the service company, and there's a prudence review, and if there are imprudently incurred costs, they will be disallowed. So we disagree with that. So the fact that these costs are set in a rate case provide Ameren, Missouri with a pretty strong incentive to keep them low, because once the costs are set, due to regulatory lag, any movement in the costs affects our bottom line. So Ameren, Missouri, and other Missouri utilities that are getting these shared support services have a financial incentive to keep them as low as possible already. We also disagree. Mr. Kleiser said that the provision in Rule 2F that would allow the Commission to eliminate the exclusions that are provided for in the rule if they have a case, have a hearing, and find that the purposes of the rule are not being satisfied. He said that was completely ineffective. We disagree with that. We think that would be an effective way for the Commission to make sure that customers aren't overpaying. So we think there are lots of protections that already exist, and as a result, there's no need to make the change to Section 2F that he proposes. And I think really to understand why 2F is there, you need to take a look at the history of affiliate transactions in the United States and in Missouri. And in Ameren's case, when Ameren Corporation was formed in 1997, when we acquired Central Illinois Public Service Company, we had to get approval of the FERC at the federal level, and we had to get approval of the Missouri Commission at the state level. And at the time, federal law required us to set up a services company, and they required shared corporate services to be provided at cost with no profit. And so that's the way we set up the company, and that's the way FERC approved it, and that's the way the Missouri Commission approved it. And, you know, it wasn't just Ameren Corporation that was set up this way. It was basically every utility around the country is set up this way. And so, and ever since 1997, well, and I guess the reason maybe this is obvious, but the reason they approved that is there are huge benefits from having shared corporate services. And the corporate services are a lot of things, by the way. It's legal services, accounting services, IT services, financial services, human resources services, any kind of support like that could be provided from a central service company to multiple utilities. And so, you know, the obvious advantages that the FERC and the Missouri Commission recognized is there's much greater efficiencies if you've got a central services company rather than having each utility have their own legal department, environmental department, IT department. It just creates efficiencies, and the fact that that customers can't be charged a profit, they can only be charged the cost of that service, makes sure that they're not going to be taken advantage of. So since 1997, that's what we've been doing, and that's what other utilities in the state have been doing. We've been providing services from the service company at cost. So the rule that the staff has drafted basically preserves the status quo. And what OPC is attempting to do is they're attempting to change the status quo, again, based on the false premise that there's the opportunity to provide a financial advantage, even when the affiliate's only charging the cost of the services provided. So we also think the practicality is if you adopted the OPC's proposal, I think there are significant practical problems. First of all the utilities would have to hire a team of people to administer, to put RFPs together. If, to the extent the market was being tested, I guess Mr. Kleiser raised the issue of benchmarking, but benchmarking is a pretty imprecise method of seeing what the market is like. I think the rule would probably require us to go out and get bids for all these services if it was changed in the way that he says it should be. We'd have to hire people to do RFPs, to review the RFPs, to contract with, if they were outside people that want a contract, and administer the contracts. And that would be no small undertaking. Second, we think the most likely result is nobody would win any bids because, third-party contractors who have to earn a profit almost certainly can't compete with a service company that's providing services at cost. So we think one thing that would happen is maybe nobody would bid on any of these contracts. But even worse, what might happen is a third party might submit a lowball bid, a below-cost bid even, to try to get their foot in the door for service to Ameren, Missouri. And if they did that, and if we ended up hiring them, what would we have to do? We'd have to, if it was an accounting, say for example, an accounting firm gives us a lowball bid for a 2-year contract to do all of our accounting, and say they win the bid, we'd have to fire all of our accountants who have all this experience. And then the next, say it was a 2-year contract, at the end of the 2 years, we would have no internal accounting department to compete against outside services. So we also think, to the extent that we're changing services in midstream, it's very disruptive to the business. You lose continuity, you lose employees who know what they're doing, balls get dropped, and so it's not in customers' interest. And we think all of these things in the long run would make the costs go up for customers, not down. So anyway, we're strongly opposed to what Mr. Kleiser is proposing. I mean, the bottom line is we think there's value in having a consistent group of dedicated employees who provide service over decades, rather than having the possibility of switching back and forth among service providers for such important things as accounting, legal services, environmental services, and things like that. So we think the way it has worked for the last 27 years has been successful and in customers' best interests, and we think the Office of the Public Counsel's efforts to undermine the status quo through this proposed rulemaking change should be rejected. Thank you.
Any questions from the commissioners? Just one moment, Mr. Kleiser. Okay. Mr. Kleiser, you wanted to make a response.
I will do it very briefly. I don't want to make this dragged out. 2 key points. First of all, again, the rule does not require competitive bidding. The OPC is not asking for competitive bidding. The rule explicitly states you can use benchmarking to reach compliance. Everything that he says, this massive straw man argument about how we have to do competitive bidding and that's going to cost money and it's going to cause all of us to lose it, completely false. Never been required. I do not understand why the companies feel like they have to do competitive bidding when the rule explicitly states they don't. Number 2, he's mentioned multiple times that they're asking to maintain the status quo. I want to make it clear. The OPC's position is to maintain the rule as it currently exists. We are the status quo. What staff is proposing is to change the status quo to say that fair market price no longer needs to be considered for certain cases. We are asking for the status quo. That it. Thank you.
Thank you. Anything further from Ameren?
Disagree with that, but no.
Okay. Was there any comments from Evergy at this point?
I won't burden the record with additional comments. I think Mr. Lowry and Mr. Byrne did a nice job, so thank you.
Thank you. We'll go across to the next table. Any comments?
Yes, good morning. Rachel Niemeyer from Missouri American Water Company. We appreciate the opportunity to make comments on the rules today. We filed our written comments on the affiliated transactions. We are supportive of the comments filed by other utilities as well. From Missouri American's perspective, we don't... I sure can. Sorry about that. Is that better? Okay, sorry.
Maybe slow down just a little.
Oh, okay, I can do that. So, from Missouri American's perspective, we are not currently under an affiliated transaction rule, and we believe that the status quo should be maintained. The current practice is effective, and it does not need to go under a new rule. We file a CAM that is reviewable. We are different from other utilities, and so there's a reason we're excluded, and we think that should continue. And the vast majority of our transactions with affiliates are for corporate services support. That said, we did provide comments to the proposed rule, specifically around the evidentiary standard, the information required from the affiliated entities in Part 7, and access to those in Part 8. And we also had minor changes to the record-keeping sections. We support staff's inclusion of 2F. We support Ameren's support for that as well. Mr. Byrne made some excellent points about the potential effects on the business if OPC's position were to take effect. And we support Ameren's response to OPC that was filed and entered as Exhibits 2 and 3 today.
That's all?
Yep, that's all our comments. We don't need to belabor the record. We filed our written comments. We don't want to take up too much time today.
I'm just going to look at Chair Hahn and Commissioner Mitchell. If you have comments, just jump in and interrupt at any time. Otherwise, we'll
Sure,
just assume.
I do have one, Judge.
I'm sorry, you had a comment?
I do.
Oh, go ahead.
Just back to Evergy and Ameren. Under the current rule, what is I guess the assurance that the services that are being provided at market rates?
Commissioner, this is Jim Lowry. In every one of our rate case, well, a couple things. Mr. Kleiser, for example, gave the example of, well, what if you're paying more than market for accountants? In every one of our rate cases, for as long as I can remember, and in part because of the Atmos decision, which is the decision of the Missouri Supreme Court about 10 or 12 years ago that basically said there's no presumption of prudence for affiliate transactions. We put on extensive information that shows that over the history of Ameren, our costs have been substantially lower with the structure that we have and the service company that we have than they would have expected to have been had we not formed Ameren and we were not sharing services and sharing these costs across different affiliates. And I think that OPC and others would argue that we actually have the burden of establishing the reasonableness of those costs. So in every rate case, we provide that information. We get dozens or hundreds of data requests that call for information about the AMS costs, Ameren Services Company costs that are part of our cost of service. We answer those. We do not in any way, shape, or form restrict access to the information because AMS is technically not regulated. We always provide that information, and the commission, staff, and all the other parties can audit and take whatever position they want about the reasonableness of those costs. And frankly, there have been almost no claim and I've been doing this for 25 plus years for Ameren, that those costs are not reasonable. And the other thing that I would mention, Mr. Byrne touched on this, Ameren Corporation, Ameren Services Company, Ameren, Missouri, have no incentive to have their service company pay more for employees or whatever, or to provide those services at a higher cost. In fact, they have a disincentive to do so, because between rate cases, if those costs go up, that goes right to the consolidated entity's bottom line, because a level of cost is baked into rates, and if you're out for 2 or 3 years and those costs go up, just normal wage increases, for example, every dollar of that increase is going right to reduce Ameren Missouri's and the other affiliates and ultimately Ameren Corporation's bottom line. So I think all of those things taken together, as staff recognized when they proposed this, and as staff comments filed this morning confirm, just simply don't call for the application of this rule to those service companies. The purpose of the rule has always been, the commission has said this, to prevent subsidization. If you're not transferring money into Ameren Corporation's pockets at the end of the day, there is no subsidization. We shouldn't have a rule that is applying to a transaction that really was never within the purpose of the rule.
Mr.
Thank
Kaiser,
you.
you also wanted to respond to Commissioner Mitchell's question?
Well, to Commissioner Mitchell's question and to Ameren's response. Again, the existing rule right now imposes the fair market price standard, which means that everything that you hear about what happens right now is under a rule that is consistent with what the OPC is asking for. They have to provide that evidence because the rule says they have to provide that evidence. The change that is being proposed by the commission staff eliminates that evidentiary standard. As soon as they are from receiving services from a service company at fully distributed cost under the proposed rule, every piece of evidence he's referring to from the affiliate transaction rule as a requirement. So just putting that on the table, everything he says about what they're doing right now is because the rule is written the way that it is and not the way staff is proposing to change it. Second, Ameren has said several times that they have an incentive to keep costs low because of regulatory lag. It's actually the exact opposite. What Mr. Lowry and Mr. Byrne haven't stated is that if costs go down in between rate cases, that flows to the company's bottom line as well. So the company actually has an incentive to increase wages during a rate case and then decrease them after the rate case to generate an additional profit flow for the company.
Commissioner Mitchell, did that answer your questions, or did you have others?
Just one more, and maybe back to Mr. Kleiser. And to your knowledge, in our rate cases, has the commission ever objected to those affiliate costs?
I don't think so, and frankly, that's not my issue here. I have no problem. I want to say this again. I have no problem with the utilities using a support services company. All I'm asking for is to maintain the evidentiary standard of requiring them to show that it's being consistent with market price. Not asking for the objection, not telling them not to, don't want that to happen. And to my knowledge, no, they haven't objected, to my knowledge. If they have, I don't know either.
And what would you say then, in practice, how would that be demonstrated?
If I was advising the utilities, I would point to the existing rule language in 3A and 3D and state that they should be using a benchmarking practice. Effectively, all they need to do is say, hey, this is how much we pay our support services company personnel. Here's how much I don't know if you use a state or national average wage is. They're comparable. It's literally that simple. If you can show that you're paying your support services accountants the same that any other Missouri accountant would be paid, you've met the qualifications of the rule as it exists, with the fair market price standard intact. In fact, and I apologize, I don't want to speak from Spire, Missouri, but we worked very hard with Spire to come up with a solution to their CAM. And the solution that we came up with, in my opinion, was to focus on using that benchmarking practice. And I know that Spire's kind of filed comments that they don't want to change their CAM, and I agree with that. I think that their CAM works well because it accomplishes the exact goal that I'm talking about using the existing language of the rule. Again, Spire may choose to disagree, but that's my answer. Does that answer your question?
It does, and maybe a follow-on question back to Evergy and Ameren. What would be your viewpoint on establishing a benchmarking practice?
Well, I guess we don't think benchmarking, I mean, it can be useful, but it isn't always the best way to measure the market. So I think one of the significant things that we disagree with Mr. Kleiser on is I don't think the fact that the Missouri Public Service Commission and the parties can review all of our costs in a rate case has anything to do with what this rule says. Even if there was no rule at all, the commission and the staff and the Office of Public Counsel would be able to exhaustively review our costs. And they would be able to, if they thought benchmarks were relevant and they wanted to use benchmarks to challenge costs from an affiliate, they certainly could do that. They have access to all the information to do that. That's a legitimate, even if there was no affiliate transaction rule at all, our costs are a legitimate line of inquiry in any rate case.
Under the rule as proposed, as soon as you're getting a service company with fully distributed cost, that closes the analysis. Because the affiliate transaction rule no longer applies at that point. And the rule states that there are no longer an evidentiary burden to establish fair market price at all. That is the change that is being proposed here. So while that may be the case now, while the utility might have to provide that information now under the existing rule, that is the change, is to eliminate that standard.
I have to say that statement is completely incorrect. As Mr. Burns said, if there was no affiliate transaction rule, ultimately we bear the burden of persuasion to establish that our cost of service in a rate case results in just reasonable rates. And nothing about the affiliate transaction rule either enhances or takes away from the commission's responsibility and authority in a rate case to determine those costs. The other thing I would say very briefly is if the current rule that is applying this asymmetric pricing to service companies is not an issue, then why has the commission found it necessary to give utilities variances from the rule so they could actually operate the way they're structured? And why did staff and the company, and we've had these variances pending for several years because, excuse me, this rulemaking has been going on and all the parties agreed it made more sense to let the rulemaking play out. Why then are variances thought to be necessary by the staff in order for us to operate the way we've operated our holding company structure for the last 30 years? Essentially, if you take OPC's suggestion, we're going to be back in a situation where the rule is sort of a square peg in a round hole. It's trying to prevent a subsidy that does not exist, and you're going to have to deal with permanent variances, which is essentially what you've had in the past.
Okay.
Thank you.
Did you have anything else, Commissioner Mitchell?
No.
Thank you. All right, I think we understand everybody's point of view from that point. I'll get to you in a minute, Mr. Kaufman, and you can make any further questions. Did Spire have any comments?
Your Honor, David Yance will comment for Spire.
David Yance on behalf of Spire. It's Y-O-N-C-E. And thank you, Chair and Commissioners, for the opportunity to comment today. I will be brief. I really have 3 points that I'd like to make. The first is really just our concerns really stem from how the proposed rules will affect our existing cost allocation manuals that have been drafted and approved by the Commission under the current rule. And so the 3 points, the first is really simply related to the required reporting. The current proposed rule suggests that the affiliate transaction report in the CAM would be filed on May 15th. We currently have a variance to that, and so we would propose language that would allow for a different date if it was agreed to between the Commission and the utility within the CAM. The second point that I would like to make is because the existing rule will be rescinded upon the effective date of the proposed rule, really any variances under the existing rule contained in existing CAMs and approved would cease to be effective with the at the effective date of the proposed rule. So really, what we're suggesting, and to Mr. Kleiser's point, we've spent a lot of time on our CAM. We've worked very hard to get our CAM where it's at with all the parties, and so we would propose to add language which would continue variances granted under our existing CAMs, so that upon the effective date of this rule, that those wouldn't just go away. And then finally, we did add just some very brief clarity on some of the definitions around derivatives. I won't go into those details. We did file comments on the record, and so all of that is there. And that's my comments.
Thank you. Are there questions from the commission?
All right.
I'm not seeing
Thank you.
any. Thank you. All right. Who's next? Mr. Kaufman?
Good morning. John Kaufman appearing here today on behalf of Consumers Council of Missouri. Generally, we are supportive of the Office of Public Counsel's position in this case. We did not file any written comments, but we do have a great appreciation for the affiliate transaction rule. We think it has worked very well since it was unanimously supported by the Missouri Supreme Court in the Atmos case, and I think it is important to preserve that status quo, which has served us well and which has helped keep rates at a relatively reasonable level by imposing that asymmetrical pricing. And the proposed rule does seem to change the status quo to create this exception, and our concern is that would become a loophole where this requirement to show either cost or fair market value, or show both, would no longer be required. As Mr. Byrne and Mr. Lowry talk about, there is the opportunity in a rate case to challenge those issues, but there would no longer be the requirement to produce the evidence. They talked about they still bear the burden of persuasion, but they would no longer have the burden to show something with regard to the fair market value. And we think it's important that if cost of service rate making is to work, that there be a requirement for that information to be produced so that other parties can analyze it. Consumers Council would probably err even on the side of requiring more competitive bids, but we are supportive of Public Counsel's position. We think that that is reasonable, that if you either have to do competitive bids or show something, benchmarking or something other than just being given the opportunity to not show anything regard to the fair market value. So we would just ask the Commission to remember that this is monopoly rate making. There are captive customers there. We think that this insistence that least cost services are proven in some way, or that there is some evidence, is very important. And so we fear that if the proposed rule is adopted, that it will lead to higher utility rates. That's our comments.
Are there any commission questions for Mr. Kaufman? Thank you.
Thank you.
Good morning, may it please the Commission. Tim Opitz on behalf of Midwest Energy Consumers Group. And I just want to comment briefly, I guess in support of the pre-filed comments related to Section 2F of the Office of Public Counsel, and in part in support of the comments of Ameren, Missouri, their initial pre-filed comments related to that. In my mind, I think that moving 2F under Section 2B, as OPC initially proposed, does two things. It preserves the exception for corporate services that this new rule is trying to implement, and then it also makes clear, at least in my mind, that the utility or the covered entity isn't supposed to be using FDC to provide an advantage or subsidy in any way. And I know Mr. Kleiser kind of, in his initial marks, referenced a few possible scenarios that, Ameren or the other utilities may say are, fantastical or imagined, but, want to make sure that there is that restriction in mind, that they're not providing a subsidy, but while also providing this exception for corporate shared services at FDC that will hopefully provide some advantage to ratepayers. And then the second point was Mr. Lowry's initial filed comments, I believe on the 6th, talked about this information provision and how there can be collaboration in the day-to-day operations, and I think that's a reasonable accommodation to make if we are to move that 2F under 2B as an OPC had initially proposed. That's all the comments I have.
Thank you. Are there any commissioner questions? Thank you, Mr. Opitz.
Thank you.
Anyone else that wish to comment about this rule? All right, does staff have comments regarding this rule?
Thank you, Judge. Staff does have comments. I'm Mark Johnson, providing comments on behalf of the staff of the Missouri Public Service Commission. I have with me today Scott Stacy and Kim Bolin, who is our director of our Financial and Business Services Division. This rule, or the changes to this rule, have been a long time coming. The original affiliate transaction rule was promulgated in 2003, primarily due to rumblings that the state would move towards a regulated, the original affiliate transaction rule was promulgated in 2003, primarily in response to a belief that our state was moving towards more of a regulated competitive environment in the electric sector. Well, that never really happened, but nonetheless, the affiliate transaction rule does serve an important purpose, and that purpose has been discussed at length today to prevent subsidization of non-regulated affiliates to our utility companies. Staff is very thankful for the comments that have been submitted in this case. Staff has reviewed those comments and submitted this morning responsive comments relating to, I think it was about 25 or 30 recommendations. Generally, staff is supportive of the majority of those comments. I can go through those individually, or I can allow our comments to speak for themselves. I think it probably will let those comments speak for themselves. However, I do want to touch just briefly on the subject of 2F. So several of our utilities in this state utilize a service company model. Staff, through its experience, has come to the conclusion that companies with the service company model typically benefit from economies of scale. Regulated utilities utilize this model, and also private industry utilizes this model, and there's a good reason for it. The provision of these, the use of the service company structure can be reasonably assumed to be less costly in most situations than arrangements in which the utility receives goods and services from unaffiliated entities at market value or from providing these services itself. Now, the provision of the service and goods at a lower cost are due to the inherent economies of scale available in the offering of a centralized service company to multiple entities, and a requirement to transact with a service company at fully distributed cost ensures these transactions will not include a profit margin for the charges associated with the provision of the goods and services, unlike the case with unaffiliated, independent third-party vendors. Now, I do want to point out that there's been discussion that removing the requirement to utilize bids or benchmarking or some other standard to measure these costs could increase costs to ratepayers. In staff's experience, we find that highly unlikely. These costs will continue to be reviewed by the Commission. And in fact, what this change primarily does is simply to treat costs associated with service companies the same way we treat costs the utilities incur in their normal business. During a rate case, staff investigates and reviews all costs incurred by a utility. That will not change. In fact, we currently do that for costs the utilities incur from their service companies. We will continue to request discovery and information regarding those costs, and we will determine whether or not staff believes those costs are appropriate and reasonable. If they are not, we will recommend adjustments or reductions or exclusions to those costs. The changes, in addition to the service company change, staff believes are necessary. The prior rule, in my experience, has been complicated and difficult to administer. You can see that by the fact that not all of our utilities currently have commission-approved CAMs. I think only 3 or 4 of them currently do. This rule will clearly articulate when a CAM needs to be filed, how it will be approved, and what needs to go into that CAM. And staff is fully supported of this rule with the changes outlined in its pre-filed comments. Thank you. I'm happy to answer any questions.
And you filed comments this morning. Should we also, perhaps we should also mark that as an exhibit like we did with Amron's responsive comments?
Yes, I would agree with that, Judge.
So I believe that would be Exhibit 4. So I will mark the comments filed by staff as Exhibit 4. Are there any commissioner questions for staff? All right. Mr. Kleiser, you had a response?
Actually, I have a question, if at all possible, because I would love for staff to be able to placate my concerns. So I really just want to ask quite simply, how is staff going to determine the reasonableness of the shared service company costs by comparing it against something if the rule has eliminated the need for the company to put forward any fair market price evaluations? What are you comparing your reasonableness of your costs against?
Staff compares it to historical data. It compares it to other costs that it has access to or benchmarks. We utilize several benchmarking devices within the context of a rate case. For example, payroll. We will utilize the Merrick system and other industry standards for payroll. And I also have Kim Bolin here, if she can actually expound on that at all.
Kim, go ahead and come up to the podium, please.
We can evaluate costs from other utilities, compare them to the ones that are in front of us for a case. We can also use, like Mr. Johnson said, Merrick, that provides payroll data. There's also other studies available we can utilize to see what cost a benchmarking cost should be.
And why can't the utilities use that then to meet the standard of the rule?
I don't know that they would have the same capability or time or effort to. Staff would be willing to do this in a rate case.
Judge, I think I'm going to interpose an objection if Mr. Kleiser is going to start cross-examining staff's representatives today. That's not how this process works.
Well, Mr. Lowry, we're here to take comments and understand people's issues with the rules. So I'm not going to allow Mr. Kleiser to cross-examine, but I think it was a reasonable question. I think Ms. Bolin answered it. And so thank you, Ms. Bolin. Are there any other comments or responses to the previous comments about this particular rule? Not seeing any. Any further commissioner questions? All right. Well, I think we can move on then to our second commission case, which is OX 2025-0105, and that is in the matter of the Commission's proposed Rule 20 CSR 4240-10.165 and proposed rescissions of 20 CSR 4240-20.017, 40.017, and 80.017 relating to HVAC services affiliate transactions. We'll just kind of go down the line as we did before. Are there any OPC comments regarding this rule?
Just very briefly, Your Honor. Again, my name's Lindsay Van Gerpen. I'm an attorney with the OPC. The OPC has submitted written comments in this case as well. We just had one suggested modification, and it was just adding a word so that the definition used the defined term, which was covered utility. And so that is our only comment, but I'm happy to take any questions.
All right. Any commission questions? Not seeing any. Are there any comments from Ameren? Rule?
We don't have any comments on this rule. Thank you, Judge.
Thank you. Or Evergy?
No, thank you, Judge.
Anything from Missouri American?
No, thank you.
No,
Spire?
ma'am.
Mr. Kaufman is no longer here. Mr. Opitz? Did staff have any, or was there anyone else that had any comment about this rule? Did staff have any comments about this rule?
Thank you, Judge. Scott Stacy for Staff Counsel's Office here for staff. Staff is in support of the proposed rule of 20 CSR 4240-10.165, and the rule prescribes a requirement for HVAC services respecting affiliated entities and regulated electrical corporations, gas corporations, and heating companies when such covered utilities participate in affiliated transactions. In heating companies. This rule prescribes the requirements for HVAC services respecting affiliated entities in regulated electrical corporations, gas corporations, and heating companies when such covered utilities participate in affiliated transactions with an HVAC affiliated entity. Staff has filed previously filed comments with staff's response to the comments that were filed by OPC, and based on the review of staff is in agreement with that change to add that language of a covered utility. And that's all I have, Judge. Any questions?
So there were no new comments besides those we already marked as an exhibit, correct?
That's correct.
Okay. Are there any commissioner questions for staff? Not hearing any. So anything further on this rule? Not seeing anything further, so we can move on. And I do apologize to everyone. This is a nice room, but there's a little bit of an echo, so when you speak quickly and not directly into the microphone, it's sometimes a little hard to, it takes just a second to discern. So if you just kind of try to slow down, everyone, and we will get through. So we can go ahead then and move on to the last case, which is OX-2025-0106. In the matter of the Commission's proposed rule 20 CSR 4240-10.175 relating to customer information of electrical corporations, gas corporations, heating companies, certain water corporations, and certain sewer corporations. And again, I will just go down our list. I believe Public Counsel, you had maybe another presentation for us.
Good morning. Yes, we do. So I will turn this over to begin to Dr. Jeff Mark from the OPC, and then I will speak after him.
Good morning. My name is Jeff Mark, and that's Geoffmarke. I'm the Chief Economist with Missouri Office of Public Counsel. I appreciate the opportunity to provide comments. I'm cognizant of the time, and we'll plow through. So customer information, our comments. Here it is. All right, just a quick prelude as to how we got here, at least from my perspective. It really starts about 6 years, 5 months, and 27 days ago. That was actually when direct testimony was due in case ER 2018-0145 and 0146. This was Kansas City Power and Light and Greater Missouri Operations rate case. My review, at the time, the context is important. Utilities at that point were aggressively pursuing AMI investment. We looked at best practices around with other states. Privacy became a germane issue that was relevant for many commissions that were wrestling at that time. My review of the commission rules produced for the entirety of the rules, so 400 plus pages. I was able to find the words privacy twice in the commission rules. They were both in telecom, and specifically over universal services. At the time, I had proposed in that rate case that the commission consider opening up a docket for a rulemaking over privacy. My suggestion was to open it up in Chapter 13 as opposed to the affiliate transactions. Staff disagreed, and I think it's neither here nor there whether or not we deal with it in the affiliate or the billing rules. On the 27th, so roughly a little over a week after that, a rulemaking workshop docket was opened up in AW 2018-0393, and it was granted by the commission. Shortly thereafter, various parties filed comments. Those included the ACLU, State Representative Bill Kidd, the Attorney General at the time, and current Senator Josh Hawley, our office, the utilities being regulated by the state, Council of City Defenders. It was a pretty diverse group that all had top-of-mind issues over customer information and privacy. That rulemaking workshop was fairly labor-intensive for about a quarter, where staff produced not only draft rules once, twice, and then a third time in 2020, where parties were able to provide comments. However, there was a lull for a good 4 years, 8 months, and 20 days. I only raised that for this real point, in that the tone and tenor of my experience working with the utilities has changed drastically over that time span. If you look at, if one were so inclined to go ahead and look at the tape recording of the workshop, you would find that the top of mind was over whether or not customer data could be commoditized and who ultimately owned that. I can speak from experience with having worked with a number of all of our utilities, quite frankly, on their cybersecurity practices, that the tone and tenor of the utility practices has changed in part because they've recognized the great liability that's inherent with getting a lot of information and being able to secure it in today's digital, artificial intelligence enabled world. So what does the public think about data privacy? I think that's important for the Public Service Commission to consider. And last night, I conducted a literature review on my own. The first one I'd like to point out is the KPMG review that was produced in 2021. KPMG found out that 86% of U.S. respondents say data privacy is a growing concern for them. 48% of respondents say they would be more comfortable with companies collecting and using their personal data if it was made fully anonymous. 40% of respondents say they would be willing to share personal data if they knew exactly how it would be used and by whom. Yet only 52% of business leaders say their company has taken active steps to demonstrate how consumer data will be used. I'd direct people to the first block quote that I took from that article. Was found that only 12% of the U.S. population would actively share their data to make online ads more relevant, only 17% that they would do it to help the business create better products, and only 30% would do it for, quote, the greater good. With those numbers in mind, KPMG recommended the following 3 recommendations. be more explicit and transparent about how customer data will be used. Give consumers more direct control over their personal data, and make data anonymous to whatever extent possible. OPC shares those sentiments. In 2023, Pew Research provided an annual report on how Americans view data privacy. Importantly, 72% of respondents were actually in favor of more government regulation of companies and what they can do with customers' personal information. And just 7% said there should be less regulation. In fact, only 21% of US adults are confident that those with access to their personal information will do what is right. And 81% of US adults are concerned about how companies use their data and how it's collected about them. And 61% of users agree that their privacy policies are ineffective at explaining how companies use their data. More recently, and this is just from 2 months ago, the Consumer Reports provided their quarterly American Experiences survey. In that, they posed the question, would you support or oppose a law that regulates how companies can collect, store, share, and use people's personal data? 78 respondents said that they would support such a law. Importantly, this occurs across partisan lines, where 81% of Democratic or Democratic-leaning respondents would support such a law, and 79 respond. Looking at that number now, that doesn't make sense. So I'm going to go ahead and cross-check that, but that's on me. Which, if any of those consumer protection topics are most interested in choosing up to 3? I'm sorry, this is the second question they posed. Now, I want to pause, just allow everybody to look at this real carefully here. Respondents here could choose 3 things effectively, up to 3 consumer protections that they would advocate for. It includes anything from, unsafe toys, contaminated lead in food or plastics, the use of artificial contamination from E. coli or salmonella. The number one point that consumers wanted protection over, advocating for laws that would prevent companies from sharing people's personal data without their knowledge. The 2024 Data Privacy Benchmark study by Cisco is often referenced by leaders within this industry. And keep in mind, the purpose for economic regulation is to provide a proxy for the market. Well, how does the market respond to this? According to Cisco, 94% of organizations say their customers won't buy from them if their data is not properly protected. Perhaps more concerning is this point: 48% of companies are entering non-public information about the company into generative AI or artificial intelligent apps. Now, why is that problematic? Well, what kind of information is being entered in by companies? 62% of that information is about internal processes, 48% on non-public information about the company, 45% over employee names or information, or 38% on customer names or information. I'm not sure how familiar the commission or the people in this room are with the various publicly available AI apps that are out there today, but the ability to process and synthesize information at a orders of magnitude rate is really unprecedented, and it raises all sorts of concerns. Right now, companies today are utilizing either commercialized AI products to synthesize information, or worst case scenario, or using apps that are available online. I point to the next point, the next number here, as illustrative controls that are put in place. Most companies that utilize Gen AI either have limitations on data, tools, or verification requirements. 27% do not permit Gen AI at all. My understanding is, I believe that's the policy of the state at the moment. I know that I can't log on to my computer and use an AI. I can't use ChatGPT or any other AI program out of concerns over privacy. I would extend those same concerns. If those are valid concerns over how customers are or potential breaches of customer information, I think the same thing would apply to our regulated covered utilities. But it's not all doom and gloom. From the Cisco study, the impact of privacy laws on organizations globally, not just in the United States, is overwhelmingly positive. On a whole, globally, 80% of companies surveyed said that having laws and regulations in place around data privacy and AI in particular provide a positive impact to their bottom line. That number is even greater in the United States at 86%. So what can go wrong? The 2024 IBM Cost of Data Breach Report suggests that global averages have increased exponentially year over year at $4.88 million currently. And the U.S. is close to $9.5 million. And 46% of those breaches involve customer information. Notably, the average cost of a data breach can be broken down into 4 components. I'll note just this bottom one in particular. That's lost business accounts for 30% of the average cost related to a data breach. I would point out again that these are captive customers. Utilities, you can't choose the utility service that you have. So this is, again, a real cost that's borne by lax privacy or potential breaches that can take place that don't necessarily apply to our regulated covered utilities. A quick infographic on data breaches, and this is from 2021, but I'll just note, even more than 3 years removed, at that point it was 17.2 billion number. Was the number of records lost in transactions according to data breaches. You'll note that those are higher on web-based platforms. They're lowest on healthcare and gaming. I'll also note that healthcare and gaming tend to be more heavily regulated industries. And this is taken from my KCPL rate case from 2016. And this is a graphical representation from the National Institute of Standards and Technology. It's effectively guidelines for smart grid cybersecurity. And in here, what you see is the identification of household activities from electric energy usage data or interval data. The real concern here is that with enough data and finite data at that, I can effectively look at any given occupant and find out a lot of information, let alone when they're going to be, what patterns they use their appliances, when they're home or not home, and there's a visual of that. So why is this important from a regulation perspective and utilities in particular? The most concrete example that I would posit out there is the threat, a potential threat related to domestic violence concerns. So the ability for an abuser to keep tabs on a victim's electric usage data or to be notified of services about to be disconnected or that they are behind on a payment can lead to harassment and potential life-threatening outcomes. Today, absent any security measures or directions from the Commission, we're concerned that potential outcome is heightened, given the ability of both AI and interval data. So would Missouri be an outlier if it adopted stronger consumer protections related to customer information? Well, as of July 2024, 20 U.S. states have passed comprehensive data privacy laws. Those states are listed. I will say that my review of states not listed there, but their public service commissions, is obviously much greater than that. A lot of our initial rules were in fact taken from the state of Illinois, who does not have a comprehensive data privacy law, but does have commission rules on the books. Some utilities have been proactive in this. For example, ComEd in Chicago Anonymous data service provides customer-level interval usage data assembled for all customers by customer delivery class in a 5-digit zip code. So specific retail customers identifiers, including but not limited to name, address, and electric count number, are omitted from the assembled data. And some commissions have been reactive. In 2012, the New York Public Service Commission ruled against New York State Electric and Gas and Rochester Gas Electric, stating, "Our investigations found that both utilities failed to meet industry standards and best practices to protect personally identifiable information of customers," said Commissioner Chairman Gary Brown. As a result, we are directing the companies to immediately take action to address the vulnerabilities on its computer billing and record systems currently used to take and maintain confidential information. Based upon the investigation's findings, the companies should further refine policies, processes, and procedures regarding confidentiality safeguards. The company should minimize access to the most sensitive personally identifiable information by maintaining a strictly need-to-know standard for contractors and employees alike. And I'll move on to the next. Oh, sorry, here we go. The company should conduct annually an incident response exercise stimulating a breach of such data. The company should establish a protocol for notification of regulators in the event of any significant cyber incident involving a possible compromise of customer data, and the company should promptly implement steps to ensure the security of all data stored on company mobile computers and removable data storage media. 5 months ago in Florida, had their mid-year resolution or mid-year conference, in that they passed the following resolution related to customer energy usage data, specifically for multi-tenant properties. That language is as follows, and I'll point to the specific relevant language here from my perspective: to authorize the sharing of their usage information with appropriate consent and privacy protections with property owners, identified third parties, and implementers of federal programs and grants to the extent provided for under state regulations. And 2, utilities to develop procedures and methods to identify customer accounts associated with multi-tenant properties to facilitate property owners access to available federal funding and other resources to reduce building-wide and tenant energy consumption. The resolution specifically calls out yes.
We're taking just a short break here for our court reporter to hook up her machine to the... Okay,
Whereas
go
appropriate
ahead.
customer protections are needed for any sharing of customer usage information, customer usage information cannot be used for marketing or to create data profiles to target customers for increasing profits. Customer data may only be disclosed to third parties with clear customer permission. Data protections and privacy safeguards are important for the preservation of public trust with the Department of Energy, utilities, and other programs. Additionally, whereas states and utilities should develop simple mechanisms for customers to make educated decisions regarding the intentional authorization to disclose their energy data. In places where no such policy is in place, individual customers should be able to access their own data and disclose them to a third-party provider. Our recommendations are consistent both with what Naruk had put forward 5 months ago, with what KPMG has recommended for best practices for companies across the globe. And specifically, I want to say that our rules are being moved forward here with an eye towards future-proofing emerging threats and safeguarding captive customers. Customers want data privacy and more regulatory oversight over data privacy. Companies overwhelmingly see privacy laws and regulations as creating a positive impact to their bottom line. Data breaches and associated costs are increasing year over year. The potential privacy risk associated with AI cannot be overstated and are emerging at a rapid clip. And customer consent, transparency in obtaining, storing, erasing data, and following a data minimization mindset will limit liability, build customer trust, and support the Commission's statutory directive to protect the public. You take the proposed rules put forward, and OPC is making 7 singular recommendations here for the Commission's consideration, which Ms. Van Gerpen will discuss in more detail. This is at the point where I pass the baton off to her, but I'll pause real quick to see if there's any questions for what I've put forward.
Are there commissioner questions for Dr. Mark? I had just a couple of quick questions. Can you just, I'm familiar with Pew Trust, but can you just tell me who KPMG and Cisco are?
Sure. Cisco is an enterprise software system with another arm that's focused with the consulting, largely on IT projects. KPMG is a dual firm, both auditing and consulting services. The report reference there for KPG is on the consulting side, specifically over data privacy.
And I'm going to mark your PowerPoint as Exhibit 5 for this hearing, and we'll get a copy from you.
Absolutely. Thank you.
Ms. Van Gerpen, now the OPC filed its points in its comments, correct? It's 7 points.
We actually only had 6 points with our written comments, and so that's what I was going to address today. Is we have read the other comments and Ameren's responsive comments, and we do have a few modifications to what we have filed as our position, and I'd like to address those for just a few minutes, if that's okay.
Yes, go ahead.
All right, thank you. So again, for my part of our oral comments today, I'd like to just go through and address the changes that the OPC would like to make to its written comments. And in fact, Brian, if I could have Dr. Mark's presentation put back up, I'll put the 7 points that we have up here on the screen. That might just be a little bit easier to follow along. So to begin my discussion today, I actually brought along copies of a red line rule that will show the changes that I'll walk through today. If I could have just a minute to pass those out.
Go ahead, and this is different than anything you filed already, correct?
It is, Your Honor.
Okay.
And
I will mark that as Exhibit 6 then.
Thank you.
And so that's a red line version of 10.175.
That is correct. So with this document, the text that is in red and underlined is what was included in our December 1st written comments, and the text that is in the purplish color is what is changed from those written comments in light of the comments that have been received. So just to briefly walk through these, as the OPC's first suggested modification was to add a definition of aggregated customer information. The OPC's original proposed definition included a number of customers to include, both residential and non-residential, as well as a limitation on the amount of the overall load attributable to each customer included in that group. And we proposed those limits to ensure that no single customer can be individually identified. But as you can see on this exhibit, the OPC has heard the feedback from stakeholders that perhaps that 15 customer residential limit was too high, And so for that reason, the OPC has limited this definition now to 5 residential customers with no individual customer's load exceeding 50% of the data in the aggregate. Our second proposed modification is to add a definition of consent. And as addressed in our written comments, we view this as perhaps our most important modification. The Commission's rule suggested that specific customer information be made available only upon consent of the customer or as otherwise provided by law or Commission rules or orders. However, without a definition of consent, it's difficult to know what that actually means. So our proposed definition addresses not only the medium of consent, but also its applicability to ongoing or successive transactions. We also included language regarding the rescission of the consent and the utility's maintenance of records around a customer's consent. Now, in light of other parties' comments, the OPC has 2 proposed modifications to its proposed definition of consent. The first is to add the word electronic to recognize that customers may give consent electronically. This was suggested by both Renew Missouri and then supported by Ameren Missouri. We do suggest including that electronic permission slightly differently than Renew Missouri, and that is to ensure that the Commission is able to opine on the form on which a utility requests permission to share data. So we suggest including it after the word written, so that qualifier that the Commission approve the form on which the utility requests customers' consent to the disclosure of their information also applies to any electronic form. Renew Missouri also asked that language be included around the continuing nature of consent for ongoing or successive transactions, and Ameren Missouri agreed with that language, and we have no opposition to that. So that is the purple language, the purple sentence in 1B there. For our third proposed modification, it's surrounding the utility-related services. So Spire and Ameren Missouri pointed to a concern about the applicability of the rule to the sharing of information in furtherance of utility-related service. With some minor grammatical edits, Spire suggested adding the definition of utility-related service found in staff's third draft rule previously filed in the working group case, AW 2018-0393, that Dr. Mark referenced. And we agree with that definition. So that's been included here as 1E. Along that same line, we suggest following Spire's lead and just incorporating the entirety of the utility-related service standard from staff's third draft rule. So that has been incorporated here as section 2F, and that language is pulled directly from staff's third draft rule filed in that working group case. For our fourth modification, this is the standard applicable to aggregate customer information in section 2B. As we explained in our written comments, we found the phrase "upon similar terms and conditions" to be sort of ambiguous. We understood the Commission's proposed rule as saying that customer consent was not required for aggregated or general customer information, but that the information would be provided to affiliated or unaffiliated entities under similar terms and conditions. It appears that other parties may have had a different understanding of that phrase. So, in furtherance of our understanding, we've proposed some clarifying language here that makes it clear that the information will be provided upon request and under the same terms and conditions applicable to all entities receiving such information unless otherwise ordered by the Commission. For our fifth modification, we suggest adding language clarifying that utility customers maintain ownership of their information at all times. This is section 2E. In response, Ameren Missouri suggested adding language that recognizes that a utility needs to use a customer's information to provide service, and we don't oppose that change. So it's been included here in the purple language for 2E. For our sixth modification, it was regarding the notifications provided to staff and OPC in the event a utility experiences a breach or a breach of security. Though these breaches are no longer unique, and in fact have unfortunately become quite commonplace, they can be devastating for customers whose information is compromised. And in the event one of the Commission's regulated utilities experiences such a breach, it will be important for the Commission to understand what happened and what information was given to the utilities customers. So the OPC suggests including language that in the event a utility experiences a breach of security, the utility provides both staff and OPC both the notices that it sends to customers as well as all drafts, including the final draft of any reports pertaining to the breach itself. In its response, Ameren Missouri suggested that while it didn't oppose providing the notices, it only wanted to provide the final draft of the report. Staff did not oppose the OPC's proposed edits or Ameren Missouri's objection to not providing those work-in-progress drafts, but staff did recommend that the utility retain all work-in-progress drafts for possible future review. You'll see here in Exhibit 1 that the OPC has maintained its originally proposed language, which would request which would require the utilities to provide all drafts of any report detailing the data breach. The OPC finds it important to remind everyone that both staff and OPC are subject to the non-disclosure provisions in Section 386.480 RSMO. So while we understand that there might be numerous drafts and those drafts could contain confidential information, it's certainly not something that staff and OPC are unfamiliar with handling confidential information. And under that statute, it would be a misdemeanor for either of us to disclose that information. Further, it's important for both staff and OPC to have access to those drafts to ensure that we can track any changes that have been made to the reports throughout the drafting process, as there have been instances where questionable material changes have been made throughout the drafting process, and the realization of that has only come out throughout discovery. So without these prior drafts, there would be no way to know when and whether those types of changes have been made without conducting that additional discovery. However, if the Commission does not accept the OPC's proposal to include language that the utility provide those work-in-progress drafts as a matter of course, then the OPC would suggest that the Commission include language requiring the utilities to at least maintain those work-in-progress drafts for possible future review, as staff kind of alluded to in their responsive comments. And finally, for our seventh proposed modification, we have suggested adding language around a customer data privacy policy. In recognition of the responsive comments to this provision, the OPC with this proposed rule in Exhibit 1 suggests leaving out the language that the Commission approved those policies. So this proposal simply states that the covered utility shall maintain and submit to the Commission the utility's current customer data privacy policy and the revisions thereto. So there would be no Commission approval of the policy. We have also slightly changed subsection 10 there in response to Ameren Missouri's concerns about the need to change the policy each time they would share information with a different individual person or entity. We understand that that could be burdensome. And so with these changes, it would only ask the policy to identify the types of persons or entities that would receive that information, as opposed to the individual person or entity that would receive that information. So with these commissioners and Judge DePell, I hope that you can see that we are trying to be reasonable. We have heard the responsive comments, we have reviewed those, and as Dr. Mark explained in his presentation, the protection of a customer's information is important. In arriving at our proposed modifications, including those updated modifications in Exhibit 1, we have tried to balance the interests of all involved. So before I leave you for what may be the last time, I want to again offer to answer any questions, and we do have the other OPC representatives here as well.
Are there any questions from the commissioners for OPC? I just had one question, Ms. Van Gerben, with what are somewhat extensive proposed revisions. Has Office of Public Counsel examined any of the fiscal costs to any of these changes, either private or public?
I'm going to turn that over to Dr. Mark.
To the changes that we are
That you're
putting forward
proposing?
today? No. I will say that the changes that we've put forward today are all responses effectively from the utilities themselves, or were included in the one case, previously drafted rules by the staff.
Okay, thank you.
The only thing that, I say the utilities, the aggregated data is another one that we had opened up, but there shouldn't be more cost for that.
That question actually brought up another question that I had read in comments, and that is the cost of data production. So at a request, who would be responsible for the cost? And if the utility is responsible for the cost, then it would drive the fiscal note. But if the requestor is responsible for the cost, then the fiscal note could, in theory, stay neutral. I did have a question about the specific language that you've proposed in 3A1 or I. I'm just kind of confused by the words. It says, it's talking about the notice to staff, council, and OPC, but it says the notice provided to customers shall be provided at the same time that it is sent to customers. I don't draw the distinction or the difference. Help me understand that better.
Sure. So if I may, I'd like to address that and then briefly go back to your first comment. So with this 3A sub A little I hope that I was following there. The notice that we're referring to there is the notice required by section 407.1500 in the event that an entity experiences a data breach. That statute requires the entity to notify customers in certain circumstances. And so with that language, we would like the utilities to provide the notice that it's sending to customers about that data breach to OPC and to staff at the same time that they send it to customers.
Okay, I see. I'm not sure it's totally clear, but I think I understand what you're saying.
And I apologize if our language is maybe not clear, but that is the notice that we were referring to there. And then Chair Hahn, in response to your concern about the costs for the data, you'll see here in Exhibit 1, we have maintained, as the Commission proposed, Section 2C, which says that the utility may set reasonable charges for costs incurred in producing customer information. It is our position that it would be the requestor, if there is a cost to put the information together, it would be the requestor who has to pay those costs. And that would include if the utility is unable to put that information together without existing infrastructure, if they have to ask a third party to put that information together for them, that would be a cost that the requestor would have to pay, or would have to bear.
I think that might also be in dispute as to whether the information exists or it has to be created, right?
It is.
Okay.
It is. And again, we would posit that because the utility could, the requestor would have to bear that cost. The utility should provide the information, and if the cost is prohibitive for the requestor because the utility has to bring in a third party to put it together, that would be how the rule deals with that.
If I may, real quick, I believe the situations that we're describing are probably going to be unique. Today, utilities are providing customer information at no cost. That's in part the cost of service, the AMI technology, the software that goes to support it. But we do recognize that there could be costs moving forward for unique load shapes, customers moving forward. I'm thinking more on the commercial and industrial side, whether that's aggregated demand response or something along distributed energy resources, DERS. All of those seem practical. And in that case, we believe in tying the regulation to cost causation.
Thank you for that clarification. I think I may need to ask the company on the companies about their estimation of the fiscal notes, but I thank you for your responses.
Judge DePill. Since this is an extensive draft that, while it incorporates the comments, it's the first time we're seeing it, can we have time to respond to it in written form?
Let me think about how that would work, because we're on a very short time frame to get whatever we get done accomplished. So let me give that a little thought. All right. We are approaching the noon time when our other hearing is supposed to start. It will start with a Q&A, but we're going to go ahead for a few more minutes until we'll see how far we can get before we have to actually break. So, was there anything else from Public Counsel? All right. Is there anything from Evergy or Ameren?
Yes, Judge, and there's probably quite a bit more than there would have been had we not gotten Exhibit 1 this morning, to be perfectly honest. So I doubt if I can finish in the time frame that you have left, but I'll proceed, and you can stop me if I can't, if that's okay. I don't want to belabor the points, but there's quite a bit that's been raised by this exhibit that needs to be addressed.
Go ahead.
So I'm going to caveat some of this because there's no way sorry. Because I don't think there's a way for me to be absolutely sure that these edits are exactly what was proposed, but I think they were based on Ms. Van Gerpen's representation, so I'm going to assume that on some of these. So I don't think we have an issue about this aggregated customer information change that they've made. I think that was something we actually agreed with, and I think the same thing is true on the consent, because I think that's Renew Missouri's. The utility-related services definition, I think, is consistent with what Spire had put out, so I believe we're okay with that. But along the lines of what Ms. Niemeyer said, it might be, fairness might suggest that we ought to have a little bit of time after this hearing ends today to make sure that we don't have some supplementary, just something we were not able to digest in the time allowed. And I know you have to think about that, and I'm not talking about a long time, because I know you have a rulemaking statutory timeline you have to deal with. But I would sort of agree that perhaps we could certainly miss something on the fly here, but I think that's okay. The aggregated customer information. There are two. I appreciate the fact that some parties have indicated, well, utility ought to just provide this for nothing, and the staff doesn't agree with that, and I don't think the OPC is supporting that position, and I think it's a very unreasonable position, and basically is going to foist on other customers, stakeholder requests for information that we have to put together. That just doesn't seem to be consistent with any cost-based rate making or any fairness, and so I would certainly hope the commission is not going to get in a situation where we have to provide information that had a cost to produce for free, and I don't think that's probably something the commission would do. But this question, and I think the chair raised it, of should we have to produce aggregated information of a certain species or a certain granularity or a certain content if we don't otherwise, we haven't produced it, we haven't developed it, and we wouldn't develop it or produce it in order to deliver utility services. It's something we don't have any utility reason to do it, but some stakeholder, it could be XYZ renewable group, it could be this group that has an agenda about whatever, they want this information because they have an agenda. They may want to go to the legislature and lobby for legislation. I don't know what they want to do with it. Could we maybe literally develop and produce it with enough time and expense, and I guess we charge them? I suppose, but I would contend that you don't want utility employees and computer systems and so on and so forth to be diverted and used to develop information that the utility doesn't need to develop in order to deliver service. I think the issue's been raised, FERC Order 2222 and aggregation. If we need to develop, if in order to operate in that environment and wherever you end up on the rules on that environment, we need to develop or have certain information that's aggregated, then again, that's going to be part of our provision of service. So we're going to have to do that. That's not going to be diverting resources to do something we don't have to do otherwise. But our concern is this upon request language, as broad as it appears to be, lets any group that wants to just say, hey, I want you to slice and dice and develop ABC, and we would have to do it. And if they have the money to pay for it, we have to do it, and they have to pay for it. And that just doesn't seem consistent with our role as a utility or the commission's role as our regulator. Let me skip over the most lengthy concern that, well, I'll go ahead and get into it, but I may need to get into it more. Spire has suggested an exemption, essentially, that we can share this information without consent in the furtherance of utility services, essentially, with our service company would be a prime example, and that's happening Sure, I'll try to. That's happening every day, probably every minute of every day, that literally service company is accessing customer information today, and the customer hasn't specifically consented to that. The customer hasn't specifically consented to that. The Spire exemption works. What OPC has proposed, which I think, and I can't verify it, there's too many words to go back to the workshop docket and see if it's exactly the same, but I think it probably is. What Spire's also use, I think, as the commission knows, we use contractors for a lot of things because it's more efficient and cost effective to do so. Sometimes people have specialized skills that don't make sense to have in-house, and so we use contractors for that. We have to share information to do that. What OPC's proposed is some language I think staff did have in a workshop draft that staff has abandoned, that has these very prescriptive contract terms that we would have to impose on every provider that we have, some of which I can absolutely tell you because our folks have told me this, the Microsofts and the Ciscos and the Amazon, the cloud service providers, et cetera, that we deal, they're not going to agree to these contract terms. And if we had to have these contract terms, we would have to redo our entire contracting system, our contract administration. We are way down the road in implementing cloud computing. We have an entire contract management, and we have forms and terms and standard terms, and we talk about this a lot in our comments in regard to the cost of compliance in the workshop docket, which I'm going to ask to mark as exhibits, and I do want to actually read a little bit from it and talk about some of it. But this issue alone was probably the primary driver for our estimation that we gave the commission about 4 years ago. And this was an educated guess, because it's very difficult to guess this, but it was a conservative guess, that the rule being talked about then that had this language in it was likely to cost north of $20 million to implement. And that really wasn't even an annual ongoing, but just to try to make it work.
For clarification, are we talking about F?
2F.
Yeah.
And we're not talking about the concept of an exemption for utility regulated services like Spire suggested in 2F. We're talking about this prescriptive you must require all these things in your contracts. And we filed comments a year or two ago when we were asked to refresh those estimates that suggested that 20 million is probably too low. I mean, just for one thing, costs have not gone down; they've gone up over that period of time. And so we would be, first of all, I think we would be out of compliance with this rule the minute it was adopted, and I don't even think we literally could ever comply unless we simply did everything, including all the IT support and all the cloud computing and everything we do now with contractors and consultants. We would just have to bring it all in-house, even though that's really not the right business decision, and it's not the right decision for our customers. So 2F is a huge problem for us. What you ought to do is do what Spire suggested and just exempt the specific consent requirement when we are sharing information with our contractors and with our consultants, with our service company, as part and parcel of their work in providing utility service, because they do that. They do things that, in effect, are providing that service for us. I don't think I have a problem with I'm jumping around, I apologize, but I'm trying to do this as quickly as I can. I don't think I have a problem with the changes on the customer data privacy provision in 3 or in 4. I think those are consistent with what we suggested. In 3A, staff has suggested that at least we should have to keep the drafts if we have a report. And I'm not going to push back and disagree with that, as long as we don't have to keep it forever, at least consistent with our data retention policies. There needs to be some limitation so that we don't have to keep paper and consume hard drive or cloud space forever. But providing drafts up front, a data breach, as Dr. Mark indicated, there's liability issues. It's going to be a big deal, and we don't ever want to have one, and we haven't had one that would trigger this statute that's referenced. But the lawyers, and I'm not talking about the regulatory lawyers, the lawyers generally, the liability lawyers are going to be all over those drafts. There's going to be all kinds of privileged information in them. The 480 statute doesn't address, we don't have to provide that privileged information. There's going to be those thought processes of the lawyers. A final report, I'm sure going to make attempts to minimize all of that, and if we preserve it through our data retention policies and it becomes an issue, then staff and OPC and Discovery can get their hands on it and deal with it, and we can deal with those privilege issues then. But I strongly encourage you not to require every graph, every grammatical change, every thought process of the lawyer somehow. We have to parse those out in those drafts up front. Bear with me, I just want to make sure I haven't missed, I've talked about the criticality of Spire's, and we have this in a written comment, so I won't belabor it, but the criticality of Spire's approach, we simply cannot operate under this rule unless there's an exception like Spire suggested, and OPC's alternative is it's completely unworkable, and it's going to cost a fortune to implement, and I don't even think we can, even if we didn't. Pardon me. I think I've talked about that issue, the upon request issue. Let me do this. I think I've probably addressed the 2F issue sufficiently, Judge. If we can mark as exhibits, I guess it was exhibits 2 and 3 in this particular rulemaking, if that's correct. We filed a response regarding cost of compliance in the workshop docket, AW 2018-0393. We filed that on September 11, 2023, and we filed our first response on March 20, 2020. And I'd ask that those respectively be marked as exhibits 2 and 3 and made a part of the hearing record, because they address in great detail some other things as well, and they address some things that are not being proposed by OPC now and that are not in this proposed rule, but they address, as I said, a central issue was this language in 2F that OPC's proposed here today, and they address those. And rather than me reading liberally from them, I think you could read them and you'll have the record evidence you need to deal with it.
I can admit those as exhibits 7 and 8.
Oh, okay, you're going consecutive, okay.
Yeah.
I thought you had, okay, that's fine.
And can you tell me again exactly what the two?
The first document is a September 11, 2023 response regarding cost of compliance filed in AW 2018-0393 by Ameren, Missouri. At least that's when the certificate of service says it was served, so I think it was filed that day. I don't have EFIS up right now. The second document is also called response regarding cost of compliance, same docket, also filed by Ameren, Missouri, and served on March 20, 2020.
Thank you. I will admit those as Exhibits 7 and 8.
Let me, real quick, I'll just make one other comment and then I'll stop. I don't think we have issues with most of the things Dr. Mark talked about. I don't think Ameren has sought to commoditize. I think that might have been a word you used, Dr. Mark. I didn't pronounce it very well. Or sell the data or commercialize it or whatever. That's really not a focus. I don't think that anything in your proposed rule, as modified by OPC and subject to the comments we had, would allow that kind of thing. So I know Dr. Mark was providing background on the need for data privacy and circumstances, but I must say that I don't think any of that has really much to do with what we're proposing and what your rule you've proposed. I think it suggests there needs to be consent if you're not using the information to provide utility services. We're not pushing back on that at all. But I just didn't want to leave the impression, and I don't think Dr. Marr would disagree with this, that there have been issues at Ameren about these kinds of issues or problems at Ameren, because I don't think that's been the case. So just didn't want to leave that impression.
Chair Hahn?
Just one question on for the customer data privacy policy. I know there are comments about, management of the utility by managing the contents of the policy. And I'm just want to understand Ameren's perspective on now that the commission is not approving the policy, but it does have to have specific criteria. What is the position of Ameren?
We had no problem with the specific criteria, with the exception of the one item that OPC has now edited, I think, in a way that satisfies our concerns. And since you're not approving it, it's not becoming a part of our tariff, which was the other concern that we had. I don't think we have concerns with 4 at this point.
Thank you.
Were there any other commission questions? Okay. Was that the conclusion of your comments at this time?
It was, thank you.
And anything from Evergy?
No, thank you, Judge.
Ms. Niemeyer, did you have comments you wanted to make at this time?
Yes, thank you. On behalf of Missouri American, we did not file written comments, but we support the comments filed by Spire and Ameren. Mr. Lowry raised a lot of the issues that I had with this most recent draft in terms of getting it quickly and reviewing it quickly. It's impossible for us to really do the analysis, but I think he did a good job of kind of summarizing the issues that it brings up for the utilities. So I want the commission to really consider that as a fact here today. As for the customer data privacy policy, I think it would be helpful if there was some sort of exemption, like if the company has to, if we can't comply, show good cause why we can't comply with each of these criteria, because it may not align with our company's direct policy. And while it would probably maintain most, if not all, if there's a way it could be accepted out, we could have a good cause waiver, that would be helpful. Again, with the drafts, it's heavily burdensome and gets into lots of other litigation that's outside the Missouri Public Service Commission's purview. So maintaining them for a period of time, I think, is reasonable, but requiring us to provide and directing a third party to provide is a challenge from our perspective. I think we're okay with the definition section. The cost to create this data is a significant concern for Missouri American. providing that information to entities that aren't part of the regulatory scheme or the regulatory practice and requiring us to do work for them is a burden that I don't believe ratepayers should be responsible for, even if they pay for it. I think that's not what our workers are supposed to be doing. And Section F creates, in a quick read, raises lots of concerns. Again, Mr. Lowry spoke very well to them. Spire provided an exemption that I believe is workable with the utilities. And I agree with the chair that the notice provided to customers shall be provided at the same time that it is sent to customers. In 3A, AI is confusing and can probably be clarified before the rule becomes final. And those are our comments. Thank you. Trying to hurry in the interest of time.
That's all right. I think we're going to have to break anyway and take a bit of an extended lunch break while the commissioners and our court reporter attend the other hearing. I don't think there's a large crowd online, so I don't expect that will go a super long time, but so let's go ahead and break for lunch until we'll plan to reconvene at 1:45 and see how that goes. Thank you all. I apologize for the break, but can't be helped. So let's go ahead and go off the record.